While we're working on the presentation, I wanted to do a couple preliminary thoughts. I really would commend the forum for preparing the fairly lengthy booklet here. It includes pages 2 through 59, the statute at large version of the AIA. And while the reason that's critical is many of the provisions in the AIA will not be codified in Title 35. For example, the covered business method provisions and the fee setting provisions will not be codified in Title 35, so it's useful to have the statute at large for that. The other item that's helpful here is that all the proposed rulemakings that we're discussing are provided for in this lengthy booklet, starting at page 123 through 323 for the trial provisions. And while one of the reasons that's very useful is we're still in the comment period for the proposed regulations. So for about another week, ending on February 9th for some of the provisions and February 10th for the rest of the provisions, comments can still be submitted by any member of the public, and those comments are entitled to consideration, so that there's still an opportunity for folks to make comments. I was asked to give about a 1 or 2 minute overview of this presentation. My hope here is to go over what the costs are to file for a post-grant review or inter-party review, why the costs are set at a particular level, and what the opportunity is for the agency to reset those fees. The next part is evidence, how evidence is provided for, how evidence will be presented to the agency and when additional evidence can be requested, as well as estoppel. I see a number of you looking through your materials. You should have been given a loose leaf binder. Within the loose leaf binder are both of my presentations. I think the second of my presentations was loaded. There should be a first presentation on post-grant review and inter-party review. Wonderful. Okay. So as Mr. Kapos indicated yesterday, there is a statutory requirement that he consider the aggregate cost of the review in setting the fee, and that there is this relation requirement to be considered by the director in setting those fees. The second the sub-bullets there indicate that there are two statutory provisions under which fees are set at the office. The first bullet indicates that we may set fees to recover the full cost of providing the service. That's our traditional 41D2 cost recovery fee setting. That can be done relatively quickly within a 12-month period. That is the provision that we used in setting the fees in the proposed rule. There are some flexibility issues with that fee setting authority. First, we must recover the full actual cost of providing the service, and there is no return of the fee should circumstances change. So you look at the circumstances when the fee is paid. Was the fee due at that time? If so, no return or refund. And that's a statutory requirement. The second sub-bullet indicates that under the AIA, there's a new fee-setting authority that allows the office to set fees, but it requires a fairly lengthy rulemaking process. There's consulting with our advisory committee, there's congressional report that has to be done. So we could not promulgate the fees for these provisions initially under our Section 10 fee-setting authority. Now, the Section 10 fee-setting authority would provide some flexibility. It would provide flexibility to stage fees and for the return of fees. We are receiving substantial comments on the fees that we're setting, and particularly the non-return of the fees that are set should a proceeding not be instituted. One of the things to keep in mind, however, is that the 41D2 fee, which is being set, is based on an assumption that roughly 30% of the proceedings are either not instituted at all or will settle during the trial. And those proceedings are in effect subsidizing the proceedings that go the distance. So be careful of what is being asked for in terms of the Section 10 fee setting. There would no longer be that element of subsidization should you go forward with a return provision. Okay, so the fees. For the average fee for an IPR, we indicated was $35,800. So that would be for an average proceeding, which would have between 21 and 30 claims. And the fee for IPR is the $47,100. What we've done is we've set the fee based on the number of claims for which review is requested. And a lot of people have asked, well, why are you doing that? Why wouldn't you set the fee based on the grounds for which the petitioner seeks the office to consider? One of the issues is that in order to be entitled to a filing date for this review, the proper fee must be paid. And of course, a post-grant review can only be filed during the first 9 months. We were very concerned that if we linked the fee to the number of grounds, that there would be contentiousness and a lot of arguments over whether or not the proper fee was paid. Because of course, if the proper fee wasn't paid, there would be no jurisdiction and the proceeding would terminate before it would be undertaken. So we opted for looking at the number of claims, which would be very easy to determine and unlikely to result in additional argument. How many claims are we expecting in the IP reviews and the post-grant review? Well, we looked at the 3-month period directly before the rulemaking process at inter-party re-examination. The number of claims for which IP re-examination was requested is fairly modest. Fully 2/3 were under 20 claims, and then an additional 8 out of 60 merely had 21 to 30. And we think this is probably the upper limit. We're going to go over the estoppel provisions, and one of the changes between IP re-examination and IP review and also post-grant review is that the estoppel provisions are targeted to the claims for which review is requested, instituted, and a final decision reached, as opposed to IP re-examination, which is directed to the entire patent. So now there's some motivation to more strictly target claims that you're concerned with in IP review that was not the case in IP re-examination. I thought we should go over the other costs. One of my colleagues had gone over the cost of filing the petition for post-grant review, $61,333. We also made estimates for a number of the other papers. For the preparation of a petition for inter-party review, we indicated an estimate of $46,000. The optional reply by the patent owner, we made an estimate of $27,000. And then the per motion cost of $44,000 to $47,000 per motion, and then the hearing cost of $6,800. You can somewhat control your costs on the number of motions that are filed, but others are fairly typical costs. But those are not PTO costs, those are estimates of the private sector costs, which are largely based on the AIPLA survey. Okay, a little bit more on the proposed fees. This provides two ends. For the under 20 claims for IPR, there's a fee set of $27,200, which recovers roughly 100 hours of APJ time. So the APJ time is $258 an hour. That's the fully burdened cost. And then it also recovers some IT costs associated with the system. For 51 to 60 claims, we estimate 246 hours of APJ time, which is the bulk of the recovered cost there of $68,000. We've laid out in the proposed rulemaking at page 6897 how many hours of judge time we expect each of these proceedings to take. Part of the commenting that we expect are whether or not those estimates are reasonable, supportable, or should be revised upward or downward. Okay. Evidence, the big change, right? So testimony and document production is permitted. The new act authorizes the office to set the standards and procedures for taking discovery with some statutory limitations. We've decided to, in our rules, provide for two types, so-called routine discovery, which is intended to be granted without intervention of the APJ, and often to accompany the motion that relies upon the evidence, as well as additional discovery, which you must seek the authorization of the APJ. The goal of having this additional discovery is twofold. First, we want to converge the issues, limit the issues as we go forward in the trial. And the second is that there is this interest of justice standard in the statute for discovery. And by requiring the party to seek authorization, we can make sure that that standard is being met. There's been a lot of feedback about why a party would have to go before the APJ to ask for discovery. However, there is a statutory requirement that the additional discovery be in the interest of justice. Okay. So, routine discovery. These are the items that we would expect that the APJs would not get involved with. So if you are going to rely upon a document that should be provided to the opponent, it's actually a statutory requirement in the petition, and it's a regulatory requirement after the petition. Cross-examination, where you rely upon an expert, you're required to make him available to your opponent. And the other one, information inconsistent with the position advanced during the proceeding. This is intended to reduce the issues by bringing forward the information that both the party opponent and, frankly, the board can use in determining the weight to give to the requested relief. There's a little flexibility in timing. The information inconsistent with your position is intended to be with the paper that causes it to be inconsistent, but it can also be provided in a short period after the paper is submitted. So these items are intended to be fairly quickly provided to the party opponent and not lengthen the proceeding at all. Additional discovery, where it gets a little more tricky. For inter-party review, the statute has this interest of justice standard. And for post-grant review, there's a regulatory good cause standard and a statutory requirement that the evidence be directly related to factual assertions. So it is not the same as U.S. District Court discovery. You have these additional requirements layered on. Folks have asked, well, what do you mean by good cause? We've indicated in our practice guide that there must be a specific factual reason for the discovery requested. And then folks will say, well, okay, that's good for post-grant review. I can tell you why I believe that discovery is necessary, and there's something specific to a grounds of rejection. What about this interest of justice? What's layered on? Well, that gets then our practice guide indicates that we will consider the overall diligence of the party throughout the proceeding and whether or not that additional discovery would be granted, as well as undue prejudice to the opposing party. So that's a more subjective standard. Live testimony. A lot of folks have asked, well, can we have live testimony at the board? Yes and no. And if you go to our proposed rule, we explain that you can file a motion with the APJ to attend, but you have to give the reasons why. Why is credibility of the witness at issue? If the issue is a science question, a fact question, you can address that with your own expert or cross of the party's expert. No need for credibility of the witness. Where you are in derivation, however, there may be a greater need to assess the credibility of the witness, and that's where we expect live testimony to be more often appropriate. Compelling testimony. Folks have asked me at this conference, what about compelling testimony? So I thought I'd raise it. Yes, we have authority under 35 U.S.C. 24 to authorize going to a district court for issuance of a subpoena. So the full subpoena power of a district court may be used. We expect that before that is granted, that the whether that compelled testimony will be ex parte, subject to cross, or inter party will already be worked out before the parties, before the subpoena power would be requested. For foreign, we're in Europe, we might as well discuss foreign testimony. When you seek additional discovery abroad, you must describe the efforts to produce it already in the United States while that has failed, and the mechanism you intend to use to compel it in the foreign jurisdiction. That's required to be in the motion seeking the additional discovery. So that's already played out. So estoppel, in order to talk about estoppel, we have to talk about final decision. Estoppel only applies when there is a final decision and only to the petitioner that continues to be in the case when the final decision is rendered. So if a trial is instituted, an IPR or PGR trial is instituted, and it's not dismissed, the office will issue a final decision. Even where all the parties settle, we may issue a final decision, but then of course there would be no estoppel because the petitioner, the proceeding would have been terminated as to the petitioner. Okay, so that's actually one of the big changes from IP re-examination is that there is this settlement opportunity and that the office may terminate without an opinion. But let's talk about the estoppels. There are two estoppels. There are the statutory estoppels which apply to the petitioner. So the petitioner comes to the agency, an IPR or PGR, fails to obtain a cancellation of the claim. He cannot request or maintain a proceeding before the office or before a district court of the ITC on any ground they raised or reasonably could have raised. And I think I'll just associate myself with the prior remarks that for IPR, the inter-party review, since the grounds are limited to novelty and non-obviousness, using a patent or printed publication, the estoppels would be limited to those grounds. But post-grant review has a much broader, the defenses are much broader. It's all grounds under 101, 102, 103, and 112, except best mode. There's been a lot of commentary back and forth on obvious type double patenting, whether that's in or out. The straight double patenting obviously would be in, which is based on 101, but obvious type double patenting may be out. There's, in the States, there are folks who have argued that in order to get estoppel for double patenting, obvious type double patenting, what you would do is you would file both an ex parte re-examination and either a PGR or IPR and ask for consolidation. An ex parte re-examination, obvious type double patenting is a permitted ground, has been since the Leonardo decision. Then you would seek to have it consolidated with the post-grant review and the IP review, and then argue that an estoppel would apply. I don't have a crystal ball on that one. Okay. The regulatory estoppel for patent owners. So for post-grant review and IP review, there's this regulatory estoppel on the patent owner whose claim is canceled, and it indicates that they're precluded from taking action inconsistent with the adverse judgment in any patent. So the question is, how does that play out? So if you present a claim that is the same or substantially the same as the invention for which the refusal was granted, you cannot pursue that in any continuing case, any reissue case. It's just over. The second item, which is listed in Rule 4273D3, is that a claim that could have been filed in response to any properly raised ground for a finally refused or canceled claim is also lost. So it's not just the claims that were in the case that were lost. It extends to narrowed claims that you could have presented in view of the ground of rejection. The third ground is any amendment to the specification or the drawings that was denied during IP review or post-grant review cannot be pursued in a subsequent proceeding before the office. As I mentioned, this is a regulatory requirement. There's been already significant negative feedback to the office about it. Some positive feedback, frankly. So it is something that you may want to consider commenting on, pro and con. It does settle disputes between petitioners and patent owners. It avoids the possibility of a patent owner having lost in a first IP review from seeking similar claims in trailer continuation. Obviously, we have a strong tradition of trailer continuations being filed at the office. But it should be interesting to see how that plays out. I think that's going to be it for my first talk, because it was intended to be 10 minutes.